consent of other side also. It may come
1-5.
1-5.
Lordship, I am appealing for the petitioner hearing in this case. All request, Your Lordship. Omen Chaudhary, he comes all the way from Silchar. Yesterday he was here. He had fixed the case on 6th of March. So if this comes up on 16th of March, it will be convenient for him.
15th of March.
16th.
16th. The prayer of learned counsel for the respondent and with the consent of the counsel for the petitioner, list the matter on 16th of March.
Obliged.
Please, Your Lordship. Lordship, I beg to mention item number 14, my lord. What has happened, my lord, here? My lord, my senior is suffering from illness, my lord. So matter may be taken up any other day, my lord. I'm praying for a Passover, my lord.
Of learned counsel for the petitioner, list the.
Deeply obliged, my lord.
Nobody appears for the respondent. Nobody's name is shown. Respondent তো দেখুন কারো নাম নাই। Yes.
May it please the Lordship, I beg for mention one order which need correction. The IAC 134/2026.
All right.
Tomorrow.
Tomorrow.
Obliged.
Please, Your Lordship. The concern of others, I beg to mention item number 8, Your Lordship.
Yes.
What has happened? It was last listed on 2012, Your Lordship. The file could not be traced back in its chamber, Your Lordship.
Number 8, learned counsel for the appellant submits that matter was last listed in the year 2010, because of which file could not be traced in the of the learned counsel. Accordingly, take some time to reconstruct the file. Is the matter again. For 4 weeks, did you? You have to collect certified copies and reconstruct the file.
Yes, Your Lordship. Please, Your Lordship.
Your Lordship, on 9/2, BA number 177 was fixed today. In the open code, the date was fixed today, but for typical mistake, it is fixed on 17/3. So your Lordship may fixed today or tomorrow, Your Lordship, as possible.
Bail application,
Bail
regular bail.
Yes, yeah.
Yes. One.
Obliged.
May I please? In item number 4, I have filed an additional affidavit yesterday. This may be requisitioned.
Item number
4.
4. All right.
Obliged.
Please, Your Lordship. Lordship, pre-arrest bail application, Lordship. This is a charge-sheeted case, Lordship. Absconder charge sheet is filed against the present petitioner, Lordship. And then the case is now pending before the additional CJM Lakhimpur, Lordship. And the section is session triable, Lordship. Therefore, Lordship, the petitioner is in apprehension, Lordship, that here he may be taken into custody because the case is session triable. Allegation is, Lordship, section 64 and 331, Lordship. Rape and 331 house trespass, Lordship. My humble prayer is, Lordship, I'm ready to cooperate with the trial, Lordship.
Is your name?
Abdul Razak,
The
Lordship.
main accused.
Main accused, my lord, his
One accused, Lordship, in this case, Lordship.
my lord, offences are also very serious in nature, my lord, allegation. He may call for scan copy at this stage, my lord.
Allegation is, Lordship, he forcefully entered into
House and committed
sexual
rape, my
intercourse with the complainant, Lordship.
lord. That is,
But more seriousness is
My lord.
required.
Since, Lordship, the case is already charged, Lordship, for the
That is not the question.
my lord,
You are still in a position to influence the witnesses.
my lord.
The call for scan copy of the TCR. Case has already been, before that you write, Heartland Council case has already been charge sheeted. Right CS number is there. See from there.
Sir, my lord.
Mhm.
charge sheet number, Lordship, 207/2025, Lordship. Dated 2/12/2020.
When?
First month, huh?
Obliged, Lordship.
Obliged.
This case, your lordships, I am appearing on behalf of respondent number 3, your lordships. If the matter is referred,
I am for the petitioner, lordship,
we
may
have no objection.
refer the matter.
What about other respondents? Nobody's name is shown.
I am for respondent number 3, Bubu Soikia, that is claimant and your lordships.
So all are for all the learned councils are for respondent number 3 as shown in the cause list. So who are 1 and 2? You are the insurance company.
No.
The appeal is by insurance
by
company.
Dul Soikia.
Dul Soikia. So claimant.
Owner of the vehicle, your lordships.
Who and Dul. Acha.
I am Bubu Soikia,
Bubu is respondent number 3.
your lordships. The long pending case, your lordships. Accident took place in the year 2008, your lordships. And last 8 years, your lordships, matter is pending before this honorable court. My client is bedridden, your lordships.
You are seeking what enhancement or was it rejected? Your claim?
I am not coming before this, owner of the vehicle coming, your lordships. Award against the owner of the vehicle. From the beginning, your lordship, last 18 years, I am fighting, your lordships.
So the basis of the reason he has come in appeal is that liability has been fixed upon him. The owner.
Yes,
Insurance company has been no liability on insurance company.
that's it. Fighting between your lordship, owner and insurance company. And as a consequence, your lordship, I am suffering last 18 years.
But the insurance company is not here. Can we refer, because the dispute is between owner and insurance company. The award itself is not in question.
I have no objection, not to claim.
Hmm?
I have no any objection. I am the appellant, so my lord. Fundamental.
No, I mean, what is the point of referring to mediation? Will insurance companies say that we will accept liability? Earlier you had submitted that it cannot be referred to mediation. There is already an order stating that release the matter for hearing, since the matter cannot be referred to mediation. Then what is the point now? Miss S. Musahari, she was appearing for respondents number 1 and 2, but her name is not shown despite direction of this court earlier. That hard learning. Hard. You are Mr.
H.J. Tamuli, my lord.
H. J. Tamuli, learned counsel for the appellant. And you are?
A. Nath.
Sir, not appearing for the respondent number 3. The name of the learned counsel for the respondents number 1 and 2. MS S. Musahari has not been shown in the cause list today. Hence, list the matter again. Friday. Showing the name of Miss S. Musahari.
Lordship. Next week, my lord.
All right.
After Friday. Date may be 6, your lordship. Next week, my lord. 27.
The name of S. Musahari as learned counsel for the respondents number 1 and 2.
27 February, lordship. Obliged.
Enhancement. Only our grievance is multiplier not put and notional income is also not proper. So accordingly, this case is pending, my lord. So it can set up by mediation, my learned friends.
You are appearing for?
I am for respondent number 1, lordship.
Who is he?
Reliance Intelligence Company.
Insurance company.
Insurance company.
Claim was 10 lakhs, 1 lakhs is fixed. That is why we enhance for it.
Third learned counsel for the petitioner, appellant. And also learned counsel for the respondent number 1, insurance company. Submitted on behalf of the appellant that the matter relates to enhancement of the awarded amount can be settled mediation. Learned counsel for the insurance has no objection. Hence, the matter is referred to the High Court Mediation Center. Parties are directed to appear before the mediator upon receipt of notice. Mediation Center is the matter.
Obligation.
May it please, my lord. According to the engaged counsel, Mr. D.K. Kalita, he has received instruction from his client, Lordship. According to them, they don't want to go for mediation, Lordship. So Lordship may fix the matter for hearing, Lordship. I am for the petitioner, Lordship.
It is submitted on behalf of the petitioner that appellant.
Appellant, Lordship, Lordship. Pardon, Lordship.
The appellant is not desirous of resolving the case through mediation. Contest the case. Hence, is the matter for hearing before the bench for which it is part heard within bracket J J on
Obliged, my lord.
Should the item be passed over for the time being?
पहले पास ओवर पर टाइम
you are appearing for whom?
petitioner Lordship.
On behalf of Mr. Loskar.
Yes, yes, Lordship. He
You have
mentioned,
already filed the application for withdrawal.
yes, Lordship.
Do you want to withdraw?
Yes, Lordship.
You're supposed to submit an affidavit.
Yes, Lordship. Yesterday we filed the affidavit, Lordship, and the record is not yet taken, Lordship. That's why in the morning, Lordship, he mentioned here, Lordship, for take the affidavit.
Not comes so soon. So
Then, Lordship,
is the matter, the additional affidavit stated to have been filed in the IA is not tagged with the record, registry to tag the same with the record and list the matter again on Friday.
I am appearing on behalf of 49, 50 and 51.
Learned counsel, Mr. So appears on behalf of respondent's number. Give the numbers.
of license.
May it please your lordship. Lordship, the service report.
May it please your lordship. I'm for the claimants, your lordship. The respondent number 1 to 8. We had filed an interlocutory application, your lordship. We are
In the appeal has come at the top, lordship. First, let me submit about the appeal, lordship. Lordship, the service on 1 to 8 is done. For 9 and 10, we had taken both way service by speed post as well as. So Lordship, the registry can give a tracking report on the speed post, Lordship. 9 and 10 are the owner and driver of the vehicle. Lordship will peruse office note dated 9/2/26, wherein it is.
Yes, what did you want to submit?
Lordship, we had filed an IA being numbered as 60 of 2026. We are praying that the insurance company has deposited 50%, Your Lordship. It can be passed so that we can withdraw the same, Your Lordship.
But in the main appeal, you write learned counsel for the appellant appears from office note dated
9/2/26.
2/26 that service report in respect of respondent number 9 and 10 has not been received back. Other respondents are represented. Registry is directed to in the tracking report from the department regard to service is respondents 9 and 10.
Also, Lordship, the usual process report.
That depends on if it is submitted by the process server.
Yes, Lordship.
So if it gets submitted, that will come automatically.
Okay, Lordship.
Is the matter again on so and so in the no.
At paragraph 7, they have mentioned that the applicants undertake to abide by any condition or conditions imposed by this honorable court while granting permission for withdrawal of the deposited amount. So, Lordship, they can give a bond because our case is based that the owner is liable for the compensation, Lordship.
But learned counsel for the applicant claimants, it is stated that the insurance company has deposited 50% of the awarded amount, and accordingly prayer has been made for allowing the respondents number 1 to 8.
1 to
8 to withdraw the said amount. Accordingly, the respondents number 1 to 8 are allowed to withdraw the deposited amount deposited by the insurance company after executing proper indemnity bond, the satisfaction of the registry court. I stand disposed of record.
I'm very grateful, Your Lord.
Hello, Pastor.
Yeah, please, Your Lordship. Lordship, during pendency of the RFA, there is a compromise which has been reached between the parties, my lords. And accordingly, a compromise agreement was signed on 8/10/2025, my lords. Accordingly, with a humble prayer, the appellant and applicant request Your Lordships to take on record the compromise which has been reached between the parties, and a compromise degree may be drawn by making that compromise agreement a part of the decree, Your Lordship, that the interest of both the parties are secured. And this application is a joint application by both the parties, Your Lordship, with an affidavit.
How many respondents? You're representing all.
Five of them are there, Your Lordship.
Learned counsel for the appellant and learned counsel for the respondents. This joint application filed by the appellant stroke applicant along with the respondents under Order 23, Rule 3, read with Section 151 CPC. Being on record of that has been executed between the distinct parties and which has been annexed to the consent application. The said compromise agreement, it appears that the parties have settled the matter on the terms and conditions mentioned in the said agreement. Accordingly, the petition in view of the compromise reached between the parties, the connected RFA number 83 of 2016 stands disposed of on compromise. The deed of compromise agreement shall form part of the decree. Where is the original? You will have to submit the original if it is to form part of the decree.
Submit that part.
The original compromise decree be marked as Exhibit X. The IA stands disposed of accordingly, and in the connected appeal RFA, right, in view of order passed in number so and so, the appeal stands disposed of in terms of the said order.
Thank you, pleasure, Lordship.
Timing kita हमें None appears for the appellant or respondent. It appears from the order sheet that the present appeal already stands abated as against the respondents number 1, 2, and 5. On the previous date also, none had appeared for the appellant. Wherefrom it appears that the appellant longer interested in pursuing the appeal. Accordingly, the appeal stands dismissed for non-prosecution.
Application. This is against the judgment of reversal matter. But petitioner before your lordship is the defendant in the suit.
Yes, what is the deficiency in the order?
Lord, the trial court dismissed the suit by holding that there is no landlord-tenant dispute, as well as the plaintiff has failed to prove that the land in possession of the petitioner is the land of the plaintiff. But the appellate court has reversed that finding and held that, my lord, there is a landlord-tenant dispute, as well as that the plaintiff is able to prove that he has that the land in possession of the petitioner is, my lord, the land belonging to the plaintiff, my lord. Lordship may kindly, my lord, come to, my lord, the trial court judgment, my lord. It starts from, my lord, page 75. My lord, issues lordship will find at page 77, my lord. But issue.
This is the trial court.
My lord.
This is the trial court judgment.
Trial court judgment, my lord. Issue is at page 77, my lord. Issues, my lord. My lord, issue number 4 here is relevant, my lord. Issue number 4.
Yes, issue number 4, whether the defendant is a tenant.
That the plaintiff is default of payment of rent from January 2008. My lord, the discussion on issue number 4 is at page 78, my lord. Hear it, my lord.
This is under the Rent Control Act.
My lord. Yes, Urban Area Rent Control Act.
Where is the discussion?
Discussion, my lord.
3 and 4 together.
3 and 4 together, my lord. May I read, my lord? Issue number 3 and 4, my lord.
Yes.
Plaintiff is claiming to be owner of the suit premises purchased from Borbari Land Development Corporation by Exhibit 1 registered sale deed dated 23/1/1989, but PWs failed to show that suit land belongs to plaintiff as PW1 deposed in cross that she cannot say the boundary of her purchased land, whereas defendant denied the boundary of the suit land premises. PW1 deposed in cross that in the west of her land, the land Dr. Kumar exists, wherein Exhibit 1 sale deed in west is mentioned 6 feet wide road only. The plaintiff failed to affirm that defendants are in her land as PW1 deposed in cross that if the land possessed by the defendant is in the land of Barbary Land Development Corporation, she cannot say. The plaintiff who did not confirm that in defendant is residing in her land of exhibit shall deed when defendants denies the boundary of the suit land, the burden lies on the plaintiffs to prove that suit premises belong to her as per exhibit 1 shall deed, which plaintiff failed to show. PW2 deposed in cross that in front of his land, the land of Barbary land is in existence, but the plaintiff in the schedule of the plaint mentioned north boundary as land of PW2. But PW2 deposed in cross that he has not able to show his land paper implying that the land of the suit premises do not belong to the plaintiff as claimed. PW2 deposed in cross that he measured the land for demarcation for several times, for which the land is in his possession, and his evidence of PW2 as deposed above land support that if plaintiff is in occupation of the land measured, the question of defendants residing as tenant over plaintiff's land do not hold good, logical and proved. PW2 failed to confirm the boundary of the suit premises as PW2 deposed in cross that in the south the land of rail, whereas in plaintiff mentioned the same as landed property of Dipti Rani Seal. The defendant denied plaintiff ownership over the suit premises as their claim is that since days of forefathers they are residing over the land of tag number 495, 494, 495 of PP number 66, which they purchased by Exhibit 1 agreement to sell from Barbary Land Development Corporation. DW1 affirm in cross that they are not occupying any land of the plaintiff, and since more than 100 years they are in occupation. DW1 deposed in cross that they have made agreement for sale with the owner of the land for 1 katha 18.5 lesa land where they are residing. DW2 deposed in cross that they are no occupying any land of the plaintiff, and the PW2 cross shows that in front of the plaintiff land, the land of Barbary Development Corporation land exists, which the defendant by Exhibit A agreement to sell negotiated to purchase as proved by DW1, DW2, where defendants are residing, which DW3 also support as DW3 deposed in cross that plaintiff is in occupation of own land and none has occupied land of the plaintiff unlawfully. The plaintiff stressed this case on Exhibit 6 rent agreement made with defendant number 1, but PW1 deposed in cross for which this suit is filed. She cannot say, and if this is reply of PW1 is taken into account, it seems that plaintiff Exhibit 6 alleged to be executed by her and defendant number 1 seemed to be doubt when defendant in WS denied any rent agreement and tenancy with the plaintiff. The Exhibit 6 don't seem to be rent agreement for the suit premises made with the defendants by the plaintiff as alleged, as there is no tenancy relation subsist between plaintiff and defendant, which DW prove. I am of the view that defendants are not tenant to be defaulter of payment of rent, and the suit for eviction on the basis of tenancy do not prove, for which the suit is barred by limitation. And then, my lord, this suit is dismissed, my lord.
What was issue number 3?
Issue number 3, my lord.
Limitation.
Limitation, my lord.
Height and limitation has been discussed together.
Yes, my lord.
Yes, now.
Against that, my lord, the plaintiff preferred appeal. Appellate judgment starts from page 91. And my lord, decision on issue number 4 is at page 96. My lord, the appellate court mainly held that, my lord, appellate court has believed that the exhibit 6, that is the rent agreement, which shows that there is landlord tenant dispute, my lord. And my lord, with regard to discrepancy in the boundary, my lord, appellate court has come to a finding that there is no discrepancy and the land belong to the plaintiff. And thereby, my lord, decreed the suit, my lord, by reversing the finding of the trial court.
It's para.
My lord, issue number 4, it starts from, my lord, page 96. And my lord, lordship will come to finding. Paragraph 21 is the, my lord, conclusion, my lord. Page 99, paragraph 21 is the conclusion, my lord.
Let us read the whole finding on issue number 4,
Yes,
discussion of the plaintiff.
Issue number 4, it starts from page 96. The case of the plaintiff is that the defendant was his tenant and the tenancy was created on the strength of an agreement on 1/2/1990, and since then he had been occupying the suit premises. But since January 2008, the defendant has stopped making payment of the monthly rent and also declined to vacate the suit premises. The case of the defendant, on the other hand, is that the suit premises belong to him and he had also executed an agreement for sale with Borbari Land Development Corporation and also paid a sum of rupees 25,000 as a purchaser, and also that he has been possessing the suit land since over 100 years. The learned counsel for the respondent has submitted that it is the plaintiff who is to prove his case because he has prayed for certain reliefs in the suit. No burden of proof lies on the defendant to prove anything, though certain facts are stated by the defendant because the defendant has not claimed any relief in the suit. I have considered this argument in the light of relevant laws, but regret my inability to agree with the same. It is true that when a party to a suit claims a relief on the basis of certain facts, the burden lies on him to prove those facts. But it is not correct to say that burden of proving a fact does not lie on a party if he does not claim any relief thereon, though the fact is asserted by him. Law is well settled that if a party asserts a fact affirmatively, the burden to prove the same lies on him. This is what plainly mandated by Section 101 of the Evidence Act. In the present suit, undoubtedly the plaintiff has to prove his case by adducing evidence because he has asserted certain facts. The plaintiff, being PW1, has clearly deposed in her evidence that she is the owner of a plot of land measuring 0 biga 1 katha 0 lesa covered by DAG number 495 of PP number 6 situated at Jyotinagar, Gabru Pathar Ward, Dibrugarh Town, Moja in the district of Dibrugarh, Assam. It is also stated that on the said land stands some houses which are covered by municipal holding number 664 of Ward number 19 of Dibrugarh Town. In support of ownership of the land involved, Exhibit 1 sale deed has been tendered into evidence, which is seen, and it is found that the land was purchased by PW1 from the Borbari Land Development Corporation. This position is, however, not challenged in this suit. Exhibit 2 is the sketch map of the land, which also clearly shows the position of land. Exhibit 3.1, 3.2, and 3.3 are the land revenue paying receipt in respect of the land of PW1. PW1 has further stated in her evidence that on 1/2/1990, the defendant Kishan Chand Dusat came into occupation of the house premises situated on her land as a monthly tenant for 11 months, and a deed of tenancy agreement was also executed. Exhibit 6 is produced as the said tenancy agreement. I have gone through the said Exhibit 6 and I have found that Exhibit 6 clearly shows that defendant number 1 executed the said tenancy agreement with PW1 for 11 months and the tenancy commenced on 1/2/1990. The schedule of the tenanted house further shows that the house is shown to have been situated on a part of the land which is again a part of DAG number 495 covered by PP number 66 of Gabru Pathar Ward in Dibrugarh Town, Moja. Thus, in my considered opinion, the plaintiff has clearly able to show that the land measuring 0 bigha 1 katha 0 lesa covered by DAG number 495 of PP number 66 of Gabru Pathar Ward in Dibrugarh Town, Moja belonged to her, and there stood tenanted house in question, which was laid out to the defendant number 1 on 1/2/1990. It is here worth mentioning that the learned trial court has, on consideration of the materials and evidence on record, come to the conclusion that the defendant number 1 was not the tenant under the plaintiff, and Exhibit 6, the alleged tenancy agreement, cannot be relied on. While doing so, it appears to me that the learned trial court was completely swayed by some oral evidence which was laid in this suit. Moreover, the learned trial court accepted the case of the defendants that the suit premises does not belong to the plaintiff and rather the same belongs to the defendants, which the defendants have been occupying since long and also agreed to purchase from Borbari Land Development Corporation by executing Exhibit A, Agreement of Sale. I have carefully considered the materials available on record and having considered the same, I am in complete disagreement with the finding of learned trial court. Firstly, the schedule of the land described in the agreement for sale relied by the defendants is different from the schedule of the land on which the alleged tenanted house is stated to be situated. Therefore, proof of the plea of the defendants that they are under an agreement of purchase of the land from Burberry Land Development Corporation would not by itself negate the case of the plaintiff, for a plain reason that the claim of the plaintiff is not towards any land, but towards only the houses standing on the land. Moreover, the learned trial court also gave undue stress on some issues relating to description of boundary of the land on which the tenanted house is situated, and also certain discrepancy which cropped up while cross-examining PW2. I have also considered those aspects, but in my considered opinion, the law is well settled that no oral evidence can negate the contents of documents. The plaintiff has been able to prove its case by documentary evidence. The learned counsel for the appellant has submitted that in a suit for eviction of the tenant by the landlord, if the landlord fails to establish the relationship of landlord or tenant, but succeeds in establish his title over the tenanted premises, still he will be entitled to a decree of eviction against the defendant. Then, my lord, some case laws are cited, my lord. Paragraph 21, my lord. In the light of what has been discussed and pointed out above, I am of the view that the learned trial court has committed error in holding that the defendant is not a tenant under the plaintiff. The said finding is therefore set aside and it is held that the defendant is tenant under the plaintiff and also a defaulter of non-payment of rent since 2008. This issue is accordingly answered in favor of the plaintiff appellant and the finding of the learned trial court stands accordingly reversed.
Yes.
But then the issue number 3 with regard to limitation, also my lord, finding it reversed. And my lord, ultimately the suit is decreed, my lord.
Yes.
Lord, my case is that, my lord, here, my lord, the plaintiff claims that, my lord, the plaintiff has purchased.
Yes.
But, the case of the plaintiff is that the plaintiff purchased the suit land from Borbari Land Development Corporation, my lord. And they, to prove the same, they have exhibited the, my lord, sale deed, my lord. That sale deed I have annexed at page 26, my lord. If lordship may come to, my lord, schedule of that sale deed, my lord, that is at page 36, my lord.
That is your sale deed with Burberry Corporation.
No, the sale deed of the plaintiff with the both the vendor is same, my lord, Borbari Land Development Corporation. But this plaintiff, there is a
Yes, page.
Page, it starts from page 26, schedule it at page 36, my lord. Page 36 is schedule, man. But
Yes.
But here, my lord, the north, it is vendor's plot number A. South railway land, east land of tag number 496, west 6 feet wide road. If it, lordship, compare with the schedule of the plaint, my lord, plaint schedule is at page 24, my lord.
Page 20.
4. Schedule in the plaint, my lord.
Yes.
But the schedule described in the plaint, it note says, my lord, road, oblique land of Anil Kumar Sil. Whereas, my lord, the sale deed of the plaintiff says, my lord, vendor's plot number A. Then, my lord, south says railway land, whereas, my lord, in the plaint, it is, my lord, landed property of Dipti Rani Sil. So, my lord, schedule is totally mismatched, my lord. Schedule is not at all matching. Whereas, my lord, the agreement for sale, Lord, the defendant, who is the petitioner here, my lord, they have there is one agreement of sale between the same vendor, my lord, Borbari Land Development Corporation and the defendant, my lord. And my lord, in that on that basis, my lord, they have paid all the dues, but sale deed could not be executed. That is agreement for sale is at page 41, my lord. And my lord, schedule is at page 45, my lord.
Forty-one is your agreement
Yes,
with Borbari.
Yes, agreement for sale, my lord. On that basis, my lord, the defendant is possessing the suit land. Page 45 is schedule, my lord. My lord, the schedule in the agreement for sale
Yes.
is
Road.
my lord, it matches with the schedule in the plaint, my lord, rather than the sale deed of the plaintiff, my lord. My case is that, my lord, the defendant, on the basis of this agreement for sale, is possessing the suit land, my lord. And there is total denial of the claim that, my lord, there is any landlord tenant dispute. And, my lord, the case of the defendant is that they are residing on the suit land from the time of their forefathers, my lord.
According to the plaintiffs, they had brought this piece of land from Borbari Corporation.
Yes, ma'am.
And according to them, you were residing there on the basis of a tenancy agreement.
Tenancy agreement.
But the schedule shown in the plaint that doesn't match with that sale deed
sale
with
deed of
Barbary
the
Corporation.
plaintiff, my lord. Rather, it matches with the agreement for sale, which I have exhibited. Is also with the, my lord, Barbary Land Development Corporation. Here in the agreement for sale, it is stated that I have paid all the dues, but due to some reasons, my lord, the ultimately sale deed could not be executed, but the possession is also handed over to me, my lord.
You are Kishan Chand Paswan.
Alias Dosar, my lord.
No, you can execute an agreement for sale claiming to be the owner of that land. But if the plaintiff has a better claim than you on the basis of his sale deed,
The agreement for
then
sale.
your agreement for sale is of no consequence.
My lord, my case is that I am possessing that different land, my lord. Both these, all these lands belongs to Barbary Land Development Corporation, my lord. Plaintiff has also purchased from Barbary Land Development Corporation, and there is also an agreement for sale. I have paid the dues, but ultimately sale deed could not be executed. But both these lands are different. Although the dag number and pata number are the same, that's why, my lord, the schedule is not matching, my lord. The schedule with the plaint as well as the sale deed of the plaintiff is not matching, my lord. Whereas the schedule in the plaint is matching with my lord, agreement for sale, my lord. So my case is that I am possessing that plot of land after, my lord, taking possession from the Barbary Land Development Corporation, my lord, and there is no, my lord, agreement or tenancy with the plaintiff, my lord.
But as per the appellate court's judgment, there is a tenancy agreement.
Tenancy
that has been
agreement, but
proved.
there is denial, my lord. In the WS, I have specifically denied that there is no tenancy agreement. Nothing is there, my lord.
You may deny.
Yes, my lord.
It depends on a matter of proof.
Yes, but my lord, lordship may then kindly see the what are the evidence, my lord. The PW2 1 and 2, my lord. The to prove that, my lord, if lordship may kindly come to, my lord, the evidence I have annexed, my lord. In chief is, my lord, almost, my lord, recitation of the plaint, my lord. If my lord may come to page 56, my lord, cross-examination of PW1, my lord. My lord, if it is the plaintiff's case, my lord, then they have to prove it, my lord.
Yes.
Nothing is proved, my lord. If lordship may come to page 56, my lord, cross-examination of PW1.
Yes, read.
The PW1 is, my lord, Srimati Dipti Rani Seal. Cross I am reading, my lord. I have instituted the case. My name is Dipti Rani Seal. I do not know the relationship between both the defendants. I have submitted the affidavit. I know that I have stated in the affidavit. I have 1 katha land in my name. I forgot from whom I purchased the land. I have forgotten if I have purchased the land from Barbary Land Development. I have submitted a trace map as Exhibit 2. I am possessing the land purchased by me. I have forgotten the length and breadth of the land. I cannot say the boundary of the land purchased by me. My husband knows details about my purchased land. Our land was measured on several occasions. I do not know who has measured the land. On the northern side of my land, the land of our vendor exists. Behind our land, the land of railway. On our west, the land of Dr. Kumar exists. I do not know if Dr. Kumar has purchased the land from the same vendor as of mine. Exhibit 2 is the map that I have submitted. I do not know if it was prepared at the time of purchase of the land. Exhibit 2 map is the part of our sale deed. There exists a road looks like in between the land of Dr. Kumar and our land. I do not know why I have instituted this case. My husband knows. It has been written why the case has been instituted against the defendants. Rest I do not know. I do not know if the house in which the defendants are residing is standing on the land of Borbari Land Development Corporation. It is not a fact that the accused were not our tenant and that did not pay any rent on any day, and no house has been constructed over land, and have instituted the false case for eviction. He has, my lord, proved nothing, my lord. Even the, my lord, the exhibit 6, that is claimed to be tenancy agreement, that is also not proved, my lord, as per law, my lord, because only they have, my lord, exhibited the photocopy. Neither any of the witnesses nor any person examined, nor the, my lord, the signature.
Was this the only witness? Who? No other witnesses were examined?
PW2, my lord, husband, my lord. Husband of PW1, my lord. My lord, PW2 is husband, my lord. His name is Anil Kumar Sil. That is his evidence starts from page 60. And my lord, cross-examination is page 67, my lord.
Yes.
May I read, my lord?
Yes.
This case has been instituted by my wife. My wife has purchased one cut of land. My wife is a housemaker. She does not know. She doesn't have any income upon her own. The plaintiff has purchased the land with the money provided by me. The land was purchased from Sri B.N. Agarwal. My lord, he says, PW2, he says, my lord, the land was purchased from Sri B.N. Agarwal.
He is the proprietor of Borbari.
My lord, Borbari Land Development Corporation.
Yes.
It is a, my lord, a corporation, my lord, although it is not mentioned.
Borbari Land Development Corporation, represented by its partner Vishwanath Agarwala
And son
Bhagwan Das Agarwala,
Kamal Kumar
Modi
Modi,
Agarwala,
Gauri Shankar, but yes, my care of B.N.
care of B.N.
Agarwala
Agarwala.
company. Yes, my lord, that is there. It would not be correct to say that the land was purchased from Borbari Land Development Corporation. Exhibit 1 is the original copy and not a certified copy. It would not be correct to say that I have submitted the photocopy of the certified copy as I have submitted the photocopy of the original. It is not a fact that I have no knowledge of deed. The name of Borbari Land Development Corporation exists as seller of Exhibit 1. Exhibit 2 map is with Exhibit 1. The measurement of land purchased by us and its boundary are mentioned in the deed. The length of the land is 78 feet. I do not remember in which side the length would be existing. The length on both the sides are not equal. The breadth at the back side is 28 feet. I do not know after leaving the road what would be the measurement in the front. Land of Dr. Kumar exists in the west of our land. He had purchased the land from the same vendor, that of mine. It appears there is a 6 feet road in between my land and land of Purna Kumar, which looks like Assamese alphabet DAW. In front of my purchased land of Borbari Land Development exists. I have purchased the land of Dag number 495. On the north and south of land is the land under Dag number 495. The remaining land under Dag number 495 belongs to Borbari Land Development Corporation. We have one deed. It is not a fact that the boundary of the sale deed is not the same with the boundary mentioned in the case. As per Exhibit 2 map, my purchased land is not attached to the main road, but there exists a byline which I do not know if it exists in the map or not. In Exhibit 1, the northern boundary has been mentioned as vendor's plot number A. Therefore, it indicates that on the northern side of my land, the vendor land exists. It has been mentioned that there exists a 6 feet land on the west of my purchased land. In the plaint on the northern boundary, my land and roads have been indicated. In my plaint, though I have shown that on the northern boundary is the land of Anil Kumar Sil, that is my land, but I have failed to submit any document. It is not a fact that Borbari Land Development Corporation has not sold any land to me. It is not a fact that as the land of vendor exists in front of our land, to misappropriate it, we have filed the case. The land has been measured officially for demarcation of boundary, and as such, said land is under my possession. My lord, I'm repeating this line, my lord. The land has been measured officially for demarcation of boundary, and as such, said land is under my possession. This is the PW2, my. Exhibit 6 is the agreement relating to rent. It is not a fact that Exhibit 6 is manufactured by me. It is not a fact that Kishan Chand Dusad did not know to sign in Hindi. It is not a fact that the signature in the second page of Exhibit 6 is not the signature of Kishan Chand Dusad. There is no signature of Deeplal Dusad in Exhibit 6. It is not a fact that no signature of Kishan Chand Dusad exists in Exhibit 6. On the western side of the rented house, the land of Purnakanta is situated on the eastern side, Sefali Talukdar and others, on north my land, and on south land of railway. It is not a fact that the boundary described by me does not tally with Exhibit 6. It is not a fact that the defendants are on the land of Borbari Land Development Corporation and not on my land. There is no rent receipt. It is not a fact that the defendants are not my tenant, as the defendants have constructed their own house on the land measuring 1 Katha 18 Lesa of Borbari Land Development by entering into an agreement. It is not a fact that the defendants are not residing in our land and as such not entitled to decree, as they are holding the land by their own right. If the land is measured from the main road, firstly the defendant's house and thereafter my land, it is not a fact that by the side of the main road, I do not have any land. It is not a fact that the defendants have never paid any rent to us. It is not a fact that they were never tenant and instituted the case falsely for grabbing the land situated in front, and that prior to purchase the land by us, the defendants were residing on the land. These are the cross-examination, my lord. So my case is the first, the schedule is totally mismatching, my lord, the schedule of the plaint as well as with the schedule of the sale deed. Rather, it matches with the agreement for sale. And second thing is, my lord, the landlord-tenant relationship, that is not proved, my lord. And he himself has submitted there is no rent receipt, nothing is there, my lord. How the rent is paid, when defaulted, nothing, neither there in the pleading nor there it is proved, my lord. Therefore, my lord, the plaintiff fails to prove its case, my lord, and the suit is liable to be dismissed. The appellate court judgment may be reversed, my lord.
Yes.
May I please also. Regarding the mismatch of the schedule, our exhibit 1 is our sale lead. That has never been challenged by them. In fact, in their WS, they have admitted that we have purchased the land from Borbari Land Development Authority. Plus, also they have admitted that we have been in possession in respect of our land and we have purchased the land. That is admitted fact. And regarding the mismatch of the schedule, Lordship, exhibit 1, regarding the sale deed, there is a sale deed. Our case is that they have executed an tenancy agreement in the year 1990, only in a respect of a part of the land, because we have already there in the land. They have executed regarding a premise measuring 20 feet by 15 feet, which has been situated in a part of my land. And regarding that, we have filed a suit for the eviction, because we have filed a suit on basis of the tenancy agreement. Therefore, we have mentioned the schedule as per as the tenancy. Lordship may kindly refer page 24, schedule of the premise. Yeah, our premise is measuring 20 feet by 15 feet. More or less roofing with CI sheet, bamboo made post and wall covered by part of holding number 664 of ward number 19, Dibrugarh, standing on a part of land measuring 1 katha covered by tag number 495 under PP number, which is bounded by north road land of Anil Kumar Sil, Anil Sil, south landed property of Mrs. Dipti Rani Sil, east Nepal Talukdar, and west P.K. Kaur. That is the schedule of the tenanted premise, lordship, not the actual whole of the land. Because we have purchased the whole land. In one part, they have taken the premise as a rented premise. And regarding their agreement for sale, it has clearly met, lordship. Kindly come. The agreement for sale, not in our tenanted premise, the schedule are also met, lordship.
So what is shown in the agreement, your sale deed, the schedule of the sale deed? That is regarding the tenanted premises only, boundaries.
Exhibit 1 is the land. It has mentioned the boundary of the whole land, 1 kathas.
Exhibit 1.
1. Say, sale deed, our sale deed, that we have purchased from Borobari Land Development Corporation. That schedule in respect of the whole land, that is 1 kathas of land. 1 katha is a big land, not a small land.
That is this page 26.
26. For page 26.
Huh?
No, page 36. Sorry.
Sale deed.
Sale deed, yes.
What is this then, page 26?
North vendors plot A, south railway land, east land of dark number 496. Because our tag is 495.
No, this page 36 schedule, which was pointed out by learned counsel for the appellant. This is regarding your sale deed.
Yes, yeah, my sale deed.
Yes.
Exhibit 1. That has never been denied by them. They have admitted that we have purchased the land. How we are in possession of the land. That is also been admitted. They are cross and WS. Their only contention is that they are not the tenant. Yep, I have come later on that. And our case is that in the year 1990, they have executed a tenancy agreement, and that has been already expired after 11 months. They have paid the rent till 2008, and their alleged agreement for sale that has been executed in the year 2009. That is important.
Just a moment. So what were you submitting, that this boundary is with regard to the tenanted premises only? That
in plain, in respect of the tenanted premises. That's
the
why
plain, page 24.
Yes, 24, yes.
That is in respect of only tenanted
Tenanted
premises.
15 foot, 25 by 15 foot. CIC house. That's why it has matched with their agreement for sale.
And this page 36 is of the entire one kotha land.
Yes, Lordship. And there one katha. And we have given the suit premises only a part, that is, it is only a part of the land. 20 feet by 15 feet will hardly cover 1 and 2 lessers. their agreement for sale, Lordship. That's why it is matched with the tenanted premises, because it is proof they are staying at the tenanted premises, Lordship. Because the schedule are same. And moreover, Lordship, I have given the tenanted premises in respect of a land and house in respect of Dag number 495. And whereas their agreement for sale, it has been mentioned. Lordship may kindly come to page 44, schedules.
Yes.
A plot of land measuring 1 katha 18.5 lasers or PP6 is covered by 494 and 495. That is the complete different schedule, Lordship. They are claiming that they are in possession of the land since 100 years, but they have executed the agreement for sale in the year 2009, Lordship. They had executed it. Our contention is that till 2008, they are paying the rent. After that, they have stopped paying the rents. In 2009, after filing of the suit, they had prepared that agreement for sale, Lordship, only to present a case that they are not the tenant.
Just what were you submitting about this 494 and 495? This doesn't match with what?
Match with the schedule of the tenanted, our tenancy agreement. That has been stated that it was situated on a part of the land under Dag number 495. But their agreement for sale, it is stated that they have agreed to purchase the land from the Gauhati Land Development Authority under Dag number 494 and 495. That is completely mismatched, Lordship. Completely different land.
But 495 is same.
495 is same. And the agreement for sale, they have prepared it in the year 2009, Lordship. That is important. Our case is that they have stopped paying the rent from 2008. And after that, they have prepared the agreement for sale. It's quite obvious, Lordship, that after 2008, they did not recognize us as the landlord. That's why they stopped paying the rents. And it was prepared after filing of the suit. Agreement for sale does not confer any title. But they have admitted our title, they have admitted our ownership, and it is also admitted that we have been possessing in our land. There is no dispute. Only dispute is the landlord tenant. And regarding landlord tenant lordship, I would like to place a judgment on the Honorable Supreme Court 2015-13 SCC 3. If the landlord able to prove his title, then eviction of the tenant on basis of the title is also maintainable, lordship. If we fail to prove the landlord tenant paragraph 14.
Where do you say that they do not dispute your sale deed? In WS, they do not deny.
In WS, they have stated that. That page 38, it's there. WS. Paragraph 8. Last part, paragraph 8. The plaintiff also purchased his land from Borobari Land Development Corporation. He has been trying to occupy the land of the defendant by illegal means, causing harassment and using power, who is a police officer by occupation. They have admitted it, that we have purchased the land. And Lordship may come to the cross-examination of DW1, Lordship, because we have entered the tenancy agreement with Kishan Dusat. He did not come to the cross to the witness box to give his evidence. His brother, Dipson Dusad, he has he was before the trial court. Cross of DW1 Exhibit A বিবাদী কৃষণ চন্দ্ৰ দুসাদে আজিৰ পৰা প্ৰায় 1 বছৰ আগতে সহি কৰিছিল। That is the agreement for sale. Exhibit A সহি কৰাৰ বাবে 1 নং বিবাদীয়ে আৰু কতো সহি কৰা নাই। Exhibit 9 ফলত নামা আমি ফাইল কৰা এই কেছত উকিল শ্যাম দত্তক নিযুক্তি দিয়ে। Exhibit 9(1) মোৰ সহি। Exhibit 9ত থকা অন্য সহি 1 নং বিবাদীৰ হয়নে নহয় মই ক'ব নোৱাৰো। 1 নং বিবাদী নিজৰ ঘৰতে আছে আৰু নিজৰ কাম কৰি থাকে। দীপ্তি ছিলে মোৰ ওপৰত 1 নং বিবাদীয়ে দিয়া কেছৰ কথা জানে। দীপ্তি আৰু 1 নং বিবাদীৰ মাজত হোৱা কথা সম্পৰ্কে কিষাণে ভালকৈ ক'ব পাৰিব। He is the person who knows better all the things.
So this Kishan, he was the person with whom the tenancy agreement was executed.
Tenancy agreement was executed with Kishan Chandra Dusad, and Dipnal Dusad is his brother, Lordship. Dipti ছিলে 1 নং বিবাদী কিষণ দুসাদে 1 নং 1/2/1990 বিবাদীয়ে ঘৰ মাহে 100 টকা ভাড়াত লৈছিল যদি মই নাজানো। He stated that he does not know anything about the tenancy agreement because Kishan Chandra Dusad is the person.
Kishan Chandra Dusad is named as the other party in the tenancy agreement.
Yes, yes. গতিকে ভাড়া চৰ্তৰ বিষয়ে মই নাজানো। He does not know anything about the terms and conditions of the agreement. 1 নং বিবাদীয়ে বিবাদীয় ঘৰটো সীমা 7 মাহৰ ঘৰটো সীমা 7 মাহৰ পিছত বৰ্ধিত কৰিলে যদি মই ক'ব নোৱাৰো। He said that he does not know anything about the enhancement of the rent. 1994 জুন 1 নং বিবাদীয়ে বিবাদীয় ঘৰত মই ও ননকি দুসাদ সোমোৱা কথা মই একো নাজানো। 1 নং বিবাদী জানুৱাৰী 2008 পৰা বিবাদীয় ঘৰত ভাড়া দিয়া বন্ধ কৰাৰ কথাও মই নাজানো। Because he is the person who came to the tenant premises subsequent, Lordship. We have stated in our plaint.
Yes. Yes.
It further stated that বাদীয়ে আমাৰ মাটি বেদখল কৰা নাই কিন্তু চেষ্টা কৰি আছে। It has been admitted that they are in possession. The only thing is that landlord tenant relationship, Lordship. I have placed the judgment which Honorable Supreme Court stated that in a case where party.
Where is the tenancy agreement?
Exhibit 6, Lordship. Exhibit 6.
Not annexed here.
Not annexed in the plain, Lordship, but it is in the record. Come. They have filed the case. Obviously, they will not annex it.
Okay, find it out. Where is that?
Lord's Exhibit 6 agreement. The learned trial court has stated that this is not the agreement, tenancy agreement, Lordship, because it has only stated in nomenclature that agreement, but the contents, we have go through the contents of the document. It's a tenancy agreement. I read it, Lordship.
Yes.
This agreement is made on this first day of February 1990 between Srimati Dipti Rani Sil, wife of so-and-so by religion so-and-so, hereafter called the landlord, and Kishan San Dusad, son of late Kutiram Dusad, by religion Hindu, by occupation service, resident of so-and-so. Whereas the landlord owns a kacha thatched house with bamboo post, bamboo frame, and bamboo wall on part of Dag number 495 or PP number 66 of Gaurupata ward, Dibrugarh town, Moja, more fully described in the detail in the schedule here and below. And whereas the tenant approached the landlord to let out her aforesaid house to him for his convenience to attend his duties at railway workshop Dibrugarh for a period of 11 months. And whereas the landlord agreed to let her aforesaid house to a tenant on following terms and conditions for a period of 11 months, commencing from 1/2/1990 and last till 31st December 1990 at monthly rent of 100, only including electricity payable within 7 days of every succeeding month, which the tenant agreed. It is hereby agreed by the between the landlord and tenant as follows. 1. The landlord will let and the tenant will take the facade house more fully described and detailed in schedule here and below on rent of rupees 100, including electricity per month payable to the landlord by the tenant according to the English calendar months within 7 days of the every succeeding month, commencing from 1/2/1990 for a period of 11 months only. That the tenant will keep the house in neat, tidy, illness and condition during the aforesaid period and will not store any inflammable goods. That the tenant shall use the aforesaid house for his residence only and will not carry out any business and or not use the house for any illegal purpose or not cause any annoyance to the neighbors. That the tenancy will stand terminated immediately on breaking of the condition herein agreed and on single default of payment of rent by the tenant to landlord. The landlord has right to evict the tenant immediately. Our contention is from 2008, Lordship. The tenancy agreement has already been expired after 11 months. That has not been renewed. But till 2008, they have paying the rent. It is admitted fact. And after 2008, they have failed to. The landlord can terminate the tenancy giving 1 month notice, and in that case, the tenant will vacate the house and hand over the vacant position to the landlord. And in case of his failure to do so, the landlord will have the right to take the possession of the house by force. The tenant will not part with the possession of the house to a third person, nor he can sublet it. That provision has already been violated, Lordship, because tenancy has been executed between Kishan San Dusat and Dipti Rani Sel. In our plane, we have stated that subsequently he has brought his brother and the other family members to the house, and subsequently they have occupied it by stop paying the rent. And the landlord, her agent, supervisor, employee, legal representative will have the right to inspect the house at any time during reasonable hours. Schedule of the thatched house having the 2 rooms and veranda measuring approximately 20 by 14 feet with bamboo post, bamboo wall, kacha floor on part of Dag number 494. The schedule it is mentioned as 20 by 14 feet, Lordship. In our plane, we have stated that subsequently they have altered it by 25 by 20 feet.
Twenty-five into 15 as per your plane.
Yes, yes, yes. We have stated in our plane because
Yes.
subsequently they have increased it with our permission.
What about the boundary? Does it match?
Yes, Lordship. In the tenancy agreement, on note private road. In the plane, it was stated road. And south, similar Dipti Rani Sil's residential house. Landed property Dipti Rani Sil. That is also match. East Nepal Talukdar others. East Sri Nepal Talukdar. That is also match. West Dr. P.K. Kaur. Borbari land development land. That is not been there because Nepal Kaur subsequently purchased the land from the Borbari land development area. Three part is already. Because Borbari land development had a vast land lordship, 36 bighas of land. They have plotted it and sold to different purchasers. The cross-examination of DW1 lordship, Dipnal Dusar, he has stated that Amar Himar Dokine Badinir, because there is a plaintiff, এক কথা মাটি আছে আৰু তাত তেওঁৰ ঘৰ আছে।
Right? DW?
In oath of cross examination of DW1 lordship, Dipnal Dusar. আমাৰ সীমাৰ দক্ষিণে বাদিনীৰ এক কথা মাটি আছে আৰু তাত তেওঁৰ ঘৰ আছে। And in his cross-examination, he further stated that Kisane, that is Kisan Chan Dusat, নিজৰ সহি হিন্দী আৰু ইংলিছতো কৰে। Tenancy agreement, his signature writing in Hindi, and it has been admitted by his brother that he used to write his name in Hindi and English also. The WS, he has written his signature in English. Thus, the aforesaid circumstances, lordship. The court has rightly passed and reversed the judgment. Petition civil revision, lordship, under 115. And under civil revision, the power of the court is very limited, lordship. To see whether any jurisdiction error has occurred or not. There's no jurisdiction error on the part of the appellate court. Rightly passed the judgment.
Yes. Yes.
only two things, my lord. My friend has submitted that in the written statement, there is admission, my lord. There is no admission, my lord. Only admission is with regard to that, my lord. The plaintiff is possessing the land purchased by him, my lord. But there is no admission that this defendant or the petitioner is residing on the land of the plaintiff, my lord. That there is no admission either on the written statement or on the, my lord, evidence, my lord. And And second thing, my lord, with regard to submission, that the schedule which is described in the plaint is only relates with regard to the suit property, my lord. That is, suit property is 25 feet into 15 feet, my lord. My submission in that regard, my lord, if it relates to the suit property, then, my lord, only one side ought to have been changed. But here, my lord, I have shown to your lordship that the entire schedule is changed, my lord. It doesn't matches with his sale deed. If one side is not matching, then all right, my lord. That can be that what he is arguing is that may be correct, but entire schedule is changed, my lord. It cannot be possible that, my lord, if a person comes in one side, then the whole, my lord, north, east, west, south will change, my lord. My lord, last thing is that, my lord, burden of proof. My lord, my friend has relied on the cross-examination of DW1 and DW2, my lord. My submission is that, my lord, it is the plaintiff who has to prove its case, my lord, without going into the weaknesses of anything of the defendant, my lord. It is first they have to prove, then, my lord, the burden shift, my lord. In this case, my lord, my case is that plaintiff has failed to prove its case. Therefore, the discharge of burden will not come, my lord.
Plaintiff can prove its case even through the cross-examination of DWs.
But he has to first prove the contents, what he is relying, because he says that he is the owner of the land as well as the tenancy, my lord. My submission is that he has failed to prove all the things, my lord.
Suppose while reading evidence in chief, PW's evidence, something is left out. But in defense, you admit that.
Yes,
That will
that
get
he will
covered.
ask, but lordship may consider that whether the thing was proved by the plaintiff or not. That is the test.
Basically, in tenancy case, lordship, proof of ownership is not required. But in our case, we have proved our ownership. It is admitted. Exhibit 1 and 6 is the agreement for sale, agreement for tenancy agreement. In both the cases, we have successfully proved they are the tenant, lordship. Obliged.
Obliged.
Yes.
Your Lordship, my lord. It is a reversal judgment, my lord. That, my lord, initially the respondent filed a title suit, my lord, for specific of performance of contract and agreement in Exhibit 1, my lord. And initially, my lord, title suit was dismissed, and subsequently, my lord, title appeal was, my lord, allowed, my lord. And, my lord, I approach before this honorable. On, my lord, kindly, my lord. 29/4/2019, my lord, subsequent question of law, my lord. Order dated 29/4/2019. 29/4, my lord, 2019. Order dated.
Yes.
Whether the agreement to transfer a part of a property wherein the vendor had no title over the subject matter of the agreement to transfer, and admittedly the consideration of rupees 12,000 was accepted by the vendor, makes the contract of sale and invalid on the ground that the vendor was not endowed with the status of the owner of the land, so promised to sell.
Yes.
In this case, my lord, the respondent, my lord, the father of the, my lord, appellant, stated that, my lord, state had execute the agreement, my lord, Exhibit 1. And in that agreement, my lord, the father of the appellant, my lord, promised to sell 2 bighas of land out of 7 bighas of land, my lord, which to be purchased later on, my lord. But the main substantial question of law, my lord, whether this agreement is enforceable in law or not, my lord. Exhibit 1, my lord. Finally, see, my lord, it is stated in the, my lord, trial court order, my lord.
Page?
Page, my lord, page 21, my lord. Issue number 6. This issue number 6, my lord. Whether the land measuring 2 bighas mentioned in the agreement dated 31/1/96 executed by the defendant is covered by DAG number 22 of Khotian Patta number 49 of village Uttar Bankata under Mauza Soigao Cotton. Number 6. The PW1 in his evidence and also subsequent examination in chief stated that defendant promised him to sell 2 bighas of land, and that in Exhibit 1, the agreement, the DAG number, Patta number was not mentioned. In his cross-examination, PW1 plaintiff stated that in the agreement, Exhibit 1, the seller of the suit land is mentioned as Dinesh Kolita. During his cross-examination, he further stated that in the said agreement, schedule of 7 bighas of land was neither mentioned nor the boundary of the land. He further stated that he did not know, apart from the defendant, who were co-owner of the said land, and he even do not know from which direction of the aforesaid 7 bighas of land defendant will sell him his part as per agreement. PW 2 and PW number 3 also during his evidence stated that description of 7 bighas of land is not specific in the agreement dated 31/1/1996. From the above discussion and also after going through the material on record, I am of the considered opinion that evidence laid by the plaintiff side as discussed above are not sufficient to prove that the said 2 biga of land falls within the 7 biga of land which was purchased by the defendant from Ganesh Das, though PW number 1 in his sheet stated that Ganesh Das has no other land in Bankata, Gao, apart from the land in question, but he could not able to prove the same by adducing any oral and documentary evidence. Record further reveals that after remand of the case from the Honorable Appellate Court, both parties were given opportunity to adduce evidence in order of proof their case, but though only the plaintiff side adduced sufficient evidence, and same are insufficient to prove the fact that land measuring 2 biga mentioned in the agreement dated 31/1/96 executed by defendant is covered by Doc number 22 Khotian Patana 49 of village Uttar Bankata, and as such issue number 6 is decided against the plaintiff. Thereafter issue number 5 discussed, my lord. In issue number 1 and 2, it is decided that there are cause of action and suit is maintainable. In issue number 3, is decided that suit is not undervalued. While deciding the issue number 4, it is decided that defendant executed an agreement 31/1/96 promising to sell 2 biga of land, but it is not proved that said 2 biga of land is covered by Doc number 22 of Khatian Patta number 49 of village Uttar Bankata, Mouja, Soigao Potton. While deciding issue number 6, it decided that plaintiff could not prove that 2 biga mentioned in the agreement dated 91/96 executed by the defendant is covered by Doc number 22 Patian Patana 49 of village Uttar Bankata under Mouja Soigao Potton. Hence, I am the considered opinion that the agreement dated 31/1/96 could not be specifically enforced, and as such plaintiff is not entitled to the decree as spread forth. Thereafter, my lord, the appellant, the respondent filed the, my lord, title appeal before the, my lord, civil judge Kamrup, my lord, and wherein, my lord, reversed the finding, my lord. Kindly see page 37.
Yes.
Point for determination of number 1. Whether the learned trial court had rightly decided the issue number 4 and 6, wherein it held that defendant had executed an agreement on 31/1/1996 promising to sell 2 biga of land, but it is not proved that the land agreed to be sold as per the said agreement is covered by Doc number 22 of Khotian Patta number 49 of village Uttar Bankagata under Mouja Sayani. The plea of the plaintiff is that defendant late Kutubali by executing an agreement on 31/1/96 has promised to sell 2 biga of land at a consideration of rupees 12,000 out of 7 biga of land to be purchased by the defendant from the village Uttar Bankata, Mouja Soigao from the owner Sri Ganesh Kolita of village Nahira, and said agreement is exhibited as Exhibit 1. According to the plaintiff, the agreement took place between Sri Ganesh Kolita, resident of Nahira, and defendant in respect of the sale of an area of 7 biga of land, and defendant in need of money proposed to sell 2 biga of land out of the aforesaid 7 biga of land and thereby took rupees 12,000. It is further stated that the plaintiff has performed his part of the contract by paying rupees 12,000 and defendant late Kutubali has also purchased the land, but defendant did not perform his part of the contract by executing the sale deed in respect of the 2 biga of land, and hence he is compelled to file the suit. Paragraph 18, the plaintiff who adduced evidence as PW number 1 has also narrated the same fact as he stated in his claim. The other two witnesses of the plaintiff, PW number 2 and PW, had also supported the case of the plaintiff, and defendant has signed in exhibit number 1 in presence of PW number 2. Furthermore, it is revealed from the record that defendant side could not check the evidence of PW2 and PW3 during their cross examination. So the fact of execution of the agreement on 91/1/96 is established, and learned trial court has rightly held that defendant has executed the agreement in favor of the plaintiff of for 2 bighas of land situated at village Uttar Bankata and took an amount of rupees 12,000 for the said plot of land from the plaintiff. But dispute is that exhibit 1, there is no mention about the DAG number, patta number of said 2 bighas of land proposed to sell in favor of the plaintiff. Now, coming to exhibit 1, it reveals from the language used is that the defendant, late Kutubali, had took an amount of rupees 12,000 from the plaintiff for shortage of his money for purchasing the land measuring 7 bighas of Kheraz Meadi land situated at village Uttar Bankakata from Sri Ganesh Kolita, resident of village Nahira, and at the time of execution of the said agreement, the defendant has promised to sell in favor of the plaintiff 2 bighas of land out of 7 bighas of land. Paragraph 20. The learned trial court has held that since there is no mention of DAG number and patta number, there is, and therefore the said agreement is not proved, for the land agreed to be sold is covered by DAG number 20 and Khotian pattern of 49 of village Uttar Bankagata Mauja Soigao Cotton. But it is an admitted fact that the nature of the land and the name of the owner of the land has been mentioned in the agreement, Exhibit 1. It is also found that the area of the land owner's name, except the surname of the land and village where the land is situated, is found to be similar as mentioned in Exhibit 1 with the sale deed. Exhibit 5, though the surname is different from that as it appears in Exhibit 1 and Exhibit 5, this will have no effect to plaintiff's case, as because the defendant, Let Kutubali himself, admitted his written statement that he has purchased the land measuring 7 bighas covered by DAG number 22 of Khotian patta number 49 of village Uttar Bankata under Mauja Soigao Patton from the Ganesh Kolita and others, though he denied later on his signature given on affidavit, and by admitting so, defendant has not disputed with the surname as it appears in Exhibit 1 and in his sale deed, Exhibit 5. Being so, though defendant had purchased 7 bighas of land from Ganesh Das and others, Hide Exhibit 5, it is established that said Ganesh Das and Ganesh Kolita, as it appears in Exhibit 1, in the same and only one person. Now, the question is whether for non-mentioning of the survey number in Exhibit 1, it will be void agreement. There is no rule of law that non-mentioning of the survey number of a particular land, an agreement to sell a plot of land will be a void contract. In Exhibit 1, there appears the consideration the area of land proposed to sell, name of the village where the land is situated, and owner's name of the said land. On the other hand, in deciding a civil suit, it is preponderance of probability of the case of both the contesting parties that should be taken into consideration. The principle and test of strict liability, proof beyond reasonable doubt, is not required to be applied in deciding the civil suit. Wherein this present case in hand, the defendant in his evidence has totally denied about execution of the agreement dated 31/1/96, but admitted about purchase of the land measuring 7 bighas of land from Ganesh Das and others, and the said land is covered by DAG number 22 and Khotian patta number 49 situated at village Bankata under Mauja Soigao Patton. Paragraph 24. The defendant witness DW2 and DW3 though denies about execution of the agreement by the defendant in favor of the plaintiff on 31/1/96, but during course of examination, these DWS have shown ignorance about execution of the Exhibit 1 in favor of the plaintiff. Moreover, defendant late Kutub Ali was not able to give cogent evidence to disprove the fact that he has not executed the agreement dated 31/1/96 in favor of the plaintiff for selling 2 bighas of land above accepting an amount of rupees 12,000 from the plaintiff. So it is proof of execution of agreement on 31/1/1996 by the defendant for sale of 2 bighas of land at consideration of 12,000 in favor of the plaintiff. So, by applying the theory of preponderance of probability, herein this case and on the basis of the evidence of both sides as discussed herein above, it can be safely held that defendant has executed a agreement on 31/1/96 to sell a plot of land measuring 2 bighas land covered by Dag number 22 of 14 Patta number 49 situated under Bankagata, Uttar Bankagata, under Mauja Soigao Potton out of the 7 bighas of land of the same Dag and Patta which he had purchased from Ganesh Das and other 5 Exhibit 5. In view of this, I am the considered opinion that the learned trial court while deciding the issue number 4 and 6 has not discussed the evidence available on record in proper perspective and also failed to appreciate the same and hence concluded at the erroneous finding. The decision of the learned trial court in issue number 4 and 6 is set aside and reversed. Is the findings of the appellate court. Now question is arise whether the exhibit 1 is the valid contract or not, my lord. Section 29 of the Contract Act, my lord. Contract Act. Section 29 of Contract Act. Contract.
Yes.
29. Agreement void for uncertainty. Agreement, the meaning of which is not certain or capable of being made certain, are void. Exhibit 1, my lord, no patta number, Dag number has been mentioned, my lord. No boundary has been prescribed, my lord. And he stated that, my lord, promised to sell 2 bighas land out for the share of 7 bighas of land. But, my lord, no boundary prescribed against that, my lord, 2 bighas of land, my lord. But the said agreement is a fake contract, my lord. And learned trial court rightly, my lord, decided, my lord, the issue, my lord, that the specific purpose is not enforceable under the law, my lord. But the appellate court, my lord, reversed the finding, my lord. On this regard, my lord, I place the, my lord, Supreme Court judgment, my lord.
Is that aspect of the matter dealt with in the appellate judgment
My lord,
regarding non-existence of boundary?
boundary and Dag number, patta number, not mentioned in the, my lord, exhibit 1. Let it go to.
Paragraph 22 of the appellate judgment,
My lord.
the appellate court has dealt only with the
Whether
non-mentioning of survey number.
survey number, that is Dag number.
Where is the
patta number.
non-mentioning of Doug number, patta number, etc. dealt with in the judgment?
My lord,
The appellate judgment, has this been discussed? It is at paragraph 20, it is said that learned trial court has held that since there is no mention of Doug number, patta number,
my lord.
agreement is not proved that the land agreed to be sold is covered by so and so Doug number. So that, how has that been
Paragraph 18, last portion, my lord.
overruled?
But that despite it is that in exhibit 1, there is no mention about the Dag number, patta number, said 2 biga of land proposed to sell in favor of the plaintiff. Annate appellate court, my lord, paragraph number 22, my lord, wrongly, my lord, held that no rule of law that non-mentioning of the survey number of the particular land and agreement to sell a plot of land will be a void contract. Section 29 of Contract Act, my lord, stating that, my lord.
Yes.
Kindly see, Malad, Apex Code Jarmes, Malad 2010-15 SCC 601.
Yes.
Void regarding Malad void contract, Malad. The appeal plaintiff are in appeal before us. They filed the suit specific performance of an agreement in respect of land measuring 4 biga 2 biga out of Hasra number 608. The trial court, in the light of the pleading of the parties, raised several issues. Issue 7A dealt with us to whether the agreement on which the suit for specific performance was based was vague, as is mentioned in paragraph 20 of the amended written statement. The trial court held that the suit for specific performance suit for specific performance could not be decreed for want of certainty as to the description of the suit property. In that view, the suit was dismissed, although the findings on another issues recorded were in favor of the plaintiff. The first appeal filed by the plaintiff was also dismissed, affirming the findings of the fact recorded by the trial court on issue 7A. The matter did not rest at that. The plaintiff filed the second appeal before the High Court. The High Court did not find any valid ground or good reason to take a different view on the concurrent finding of the fact recorded by both the court below, hence this appeal. The learned counsel of the appellant strongly contended that all the court committed an error in dismissing the suit of the plaintiffs. According to him, from the said suit agreement, it is clear that total area of land in Khasra number 608 is 12 bighas, 1 bissa, out of which the defendant agreed to sell only 4 bigha and 2 bissas. The property in question also included a house built therein. The learned counsel argued that it was possibility to grant a decree for specific performance, having regard to the description in the agreement itself that the remaining area was available with the defendant. All the courts found it difficult to identify the suit property out of total extent in the absence of boundaries or other specification. In support of his submission, that is the submission and paragraph number 7. 6. In Qatar Singh versus Rajinder Singh, it is held that where a joint property is sold by one co-sharer, such agreement could be enforced to the extent of the share of the person who executed the document. It is ruled that there is a difficulty in demarcating the same. The decree of to the extent of his share can be granted and property can be carved out by filing the suit for partition. But the position in the present case is different, that a portion out of the total larger extent was agreed to be sold, but without specification of the area agreed to be sold. It is clear from the suit agreement that no boundaries of the suit property which was sold are specified in the agreement. It is not clear from what point the area is to be measured. It is also not clear that this 4 bigha 2 visas is a portion of the land situated in the middle of the total land or in one portion or at the extreme end or at the particular place. In other words, there is no clear identity of the property agreed to be sold. The courts are not expected to pass the decree which is not capable of enforcement in the court of law. If the agreement of the learned counsel for the appellant, it is to be accepted. If a degree is to be granted for specific performance without identification of the suit property, it will not be possible to enforce such a degree. This court in Nehar Singh versus Harnak Singh in para 5, it is also taken view that if the property itself cannot be identified, the relief of specific performance cannot be granted. In these circumstances, and looking into the concurrent finding of the fact recorded by the court below, I do not any merit in this appeal. The appeal is dismissed.
Yes.
Secondly, my lord, this honorable court also passed order, my lord. I have also 2025 to GLT 592.
This one, legal years of Jamal Khan.
Jamal Khan. In that case also, my lord, the second appeal is, my lord, dismissed. On that downward, that the exhibit 1, exhibit, my lord, the agreement is not mentioned any tag number, patta number of any boundary.
Yes.
My lord, relied on my lord, section 93 of Indian Evidence Act. '93 of Indian Evidence Act.
Yes.
Exclusion of evidence to explain or amend ambiguous document. When the language used in a document is on its face ambiguous or defective, evidence may not be given of fact which would show its meaning or supply its defect. Exhibit 1 is the ambiguous document, my lord. Is not a valid contract, my lord. Therefore, my lord, the evidence, subsequent evidence that may not be, my lord, considered, my lord. A humble submission, my lord, the learned appellate, my lord, erroneous findings, my lord. Therefore, my lord, it is that, my lord.
Which part of this second judgment you were relied upon, paragraph?
My lord.
Our High Court judgment.
High Court judgment, my lord. Jamal Khan, my lord.
Yes.
My lord.
Which para?
Paragraph 18, 19. Paragraph number 18 and 19. Also, bench also relying the Pawan Kumar Datta judgment 2010 15 SCC 601. Paragraph number 19, my lord.
To sum up, your submission is that the agreement was bad for vagueness and therefore
Not enforceable.
not enforceable, so it could not have been decreed. All right.
So my learned brother has advanced his argument beyond the question of substantial question of law framed by the Honorable Court,
Let's go back to it. I forgot.
as well as the pleadings. I am coming to that. Substantial question of law was formulated with the Honorable Court whether the agreement to transfer a part of a property wherein the vendor had no title over the subject matter of the agreement to transfer, and admittedly consideration of rupees 12 lakhs was accepted by the vendor, makes the contract sale an invalid one on the ground that the vendor was not endowed with the status of the owner of the land so promised to sell. That was the substantial question of law.
Question was regarding lack or presence of ownership.
Yes, that is the. Now, my learned brother has advanced his argument that uncertainty of the document, section 29 of the Contract Act, that is not the substantial question of law before your lordship. Now, what is their pleadings? Whether this argument advanced presently before this honorable court, what is the before the trial court or as well as the appellate court? Pleadings is different. My case, so far I am the respondent, I was the plaintiff in this case, that the present appellant who was the defendant, predecessor of the defendant, he took an amount of myself for the purpose of purchasing a 7 bighas of land from somebody else, Ganesh Kolita alias Das. And he agreed that when he would purchase it, then he would sold out 2 bighas of land to me. At that time, he was not that owner of that property. Admittedly, he was not the owner of the property. And therefore, he became the owner of the property by the Exhibit 5. In spite of having he acquired the title over the property, he did not execute the agreement. Because at that time, it was not possible on his part to identify the area. Only 2 bighas. Because at that time, he was not the owner. When he will be the owner, he will enter the registered agreement or otherwise execute the sale. You take this one. This is your 2 bighas of land. That was the arrangement probably at that time. Because when he entered into the agreement, this was the arrangement. I filed a suit for special performance of contract. What plea he has taken? No, I did not execute any agreement with you. That was the pleadings. That was the pleadings. Lordship, page 11, written statement of the along with memo of appeal. Relevant para 6, page 12. The state, Lordship got it. The statements made in paragraph 1 of the plaint are false, incorrect, and denied by the answering defendant. The answering defendant purchased 7 bighas of land covered by tag number 22 of Pata number 49 of Blaze Uttar Bankakata, Moja, Soegaon, Pantan from Ganesh Kolita and others by their own money. That also been denied. The answering defendant did never execute any agreement with the plaintiff on 31/196. If you has taken the plea, you would have filed a counterclaim. There is a false document you want to enforce from court of law. A declaration is to be made. That is a false document. No counterclaim has been filed. Rather, he has taken the plea. In that written statement, he has not taken the plea. No, it is an uncertain property. Under section 29, it is that the special relief cannot be granted. If I am go to the entire, because in paragraph number 7, Receipt of 12,000 also denied. Everything has been denied. So, but he did not file any counterclaim for declaration that the document to be enforced is a false and document is not binding upon me. No counterclaim has been filed. Not a single averment has been made before the trial court by way of amendment pleadings that it is document is uncertain. I have executed the agreement, but it is uncertain, so that is not enforceable. And to that effect, no issue has been framed by the trial court, because ought to have been framed the issue that whether the document is to be enforceable as it is uncertain. Rather, what issues were framed, whether issue number 4 at page 18 of the trial court judgment, internal page 18, whether the defendant executed an agreement on 31/1/1996 promising to sell 2 bighas of land covered by DAG number 22 of Pata number 49 of Blaze, Uttar Bankakata, Moja Soyagaon Pantan for consideration of rupees 12,000 to the plaintiff. That issue has been decided by the learned trial court, holding that yes, agreement has been executed. Agreement has been executed, but later part, it is not enforceable. I am not on these issues. That issue was not framed at that time. Whether it is for non-mentioning of DAG number and Pata number, it is not enforceable. No issue is there. Now the question is whether agreement was executed. Yes, agreement was executed. What is his pleadings? I am not executed in agreement. Issue has been framed that the agreement was executed. Whether that findings given in issue number 4 has been challenged before the appellate court as well as before the honorable court. They could have filed a cross objection because appeal was filed by me before the appellate court. That fact admitted that although you have denied the execution of the agreement for sale with the plaintiff, but that fact has been disproved. Court admitted, court held that the agreement you have executed. Now the question remains whether that is to be enforceable. Learned trial court, in deciding the issue number 6, held that as there is no DAG number and Pata number, though agreement is there, but it's not enforceable. That is the question. Now, although there is no pleadings, court held that no, as there is no DAG number and Pata number, so that is not enforceable. Whether this is identifiable or not, the question is later on, because you have purchased by Exhibit 5. You are admitting it, that you purchased that 7 bighas of land that following from that person's Ganesh Kolita alias Das. We have stated because so far agreement is concerned, he has written as Ganesh Kolita. Later on, he has shown that it is Ganesh Das. All right. At that time, you not became the owner of that property. But later on, by Exhibit 5, you became the owner of the property. Whether he has proved it, that you see that Ganesh Das had other property at Bankakata village, and I have also agreed to purchase that plot of land, said Ganesh Das. So that is why this agreement is not enforceable in respect of this land. Whether such type of evidence was laid by him. No, rather trial court held that the plaintiff has amply proved that Ganesh Das had only that land at village Bankakata, Moja Soitan. This is 7 bighas of land and not the other land. Then in respect of what you have agreed to purchase, this is the land. In respect of what you have agreed to sold, this is the land. Now, out of 7 bighas of land, that number Patana you have not given. I have no insisted upon that time. But fact remains that you had purchased, you agreed to purchase 7 bighas of land, and later on by Exhibit 5 you have purchased it. That is the 22, that is the 7 bighas of land covered by DAG number 22, not the other land. If that is the position, who prevented you? You are giving to give owner of that agreement you have entered into. But later on you have taken deeply, no, I have never executed this agreement. All right, your plea is 100% correct, then why you have not come with a counterclaim? That this agreement is not enforceable, is liable to be cancelled. Who prevented you? Rather, you have admitted that yes, I have entered into an agreement because it was observed by the learned trial court as well as the appellate court, first appellate court. So agreement is there. Now, on the basis of that, this second appeal has been preferred before this honorable court, and substantial question of law has been formulated. What? Whether the agreement to transfer a part of property, that is 7 bighas of land, part of the property, where the vendor had no title at that time. That means you have agreed, you have admitted that agreement is there, but at that time I was not the owner. Admittedly, you are not the owner. Subsequently, you became the owner by the Exhibit 5. That is why I filed a suit against you for specific performance of contract. That is why substantial question of law has been formulated. Whether the agreement to transfer a part of the property wherein the vendor had no title over the subject matter of the agreement to transfer, and admittedly, the consideration of rupees 12,000 was accepted. That is also admitted by the vendor. That is also accepted. Makes the contract of sale invalid. Why it is to be declared as invalid? Because I was not the owner. I was not the owner. That is why it is to be declared invalid. I was not the owner. Subsequently, I became the owner. It is not disputed. And subsequent question of husband, they have pursued before this honorable court. This will be the subsequent question of law. What? Then makes the contracts invalid. Why it is to be invalid? Not this argument advanced by my learned friend today before your lordship.
What to do now?
Lordship, now section 43.
No. Learned counsel has not addressed the court on the substantial question of law,
Then
but on something else.
section 43.
Then, my lord, this honorable has power to frame the substantial question of law.
No,
It's a different issue.
it's a different issue. He did not touch his subsequent question of law.
You became aware of that situation when the learned trial court passed its
Yes.
judgment.
Yes.
That this could be one of the.
Yes.
So that should have been a matter that you should have placed before the court.
No, not before the first appellate court. Whether this plea can be taken before the honorable court as before the second appellate court, new plea. This is not permissible. There is a plethora of decision of the honorable apex court as well as our honorable high court. New things cannot be.
Yes, anyway, we'll have to continue on another day. I'm not sitting in the second of today. So, given agreed date. And we'll give him one opportunity to address at least on the substantial question of law,
Lordship.
because otherwise it will feel